I was on evergreening before the short adjournment, and I have made my principal point, which is that my learned friend's pleading, we say, relies on an inference to be drawn from mere reapplication. And we say that's not good enough. Hasbro is the reference. And I was making a subsidiary point there because Hasbro says it's not just not against the scheme of the regulation, just to show you that the scheme of the regulation specifically contemplates that there will be overlapping registrations. And the reason I took you to recital 8, my Lord Justice Arnold was ahead of me there, is that one can have either or the national or the EU mark, but as recital 8 expressly contemplates at the very end, or both. And my Lord Justice Arnold pointed out the purpose of seniority in subsection 3. Of course, one doesn't need to surrender, it's just the benefit that comes if one does surrender. The reason I took you straight to 4 is because this is again like my earlier point. In the scheme of the regulation, there is something that counters the very inference that my learned friend seeks to say is implicit, that the only reason why one would want to reapply is because you haven't made any use. By showing you that the very scheme of the regulation contemplates something else, again, we say, that highlights why this edifice of inferences is so thinly built. Now, in this case, my lord, my lady, the 343 mark, which is the one that we do rely on, the EU mark, does in fact claim seniority from the UK mark. In other words, it is one of those marks that seeks to take the benefit of Article 39. And as I say, you can see from subsection 4 that it's expressed that that seniority claim is dependent on the earlier mark being non-revocable. In other words, that it isn't vulnerable to a non-use challenge, because otherwise you can't take the benefit of seniority. So that in claiming seniority for the later EU mark, you are effectively expressly saying that you consider the earlier mark is not vulnerable in that way. Now again, here I begin to get into the point that my Lord Justice Arnold said to me earlier, was me descending into potential answers to the bad faith allegation. I'm not meaning to do that. I'm merely meaning to show you why, in these circumstances, the inference that my learned friend seeks to draw hasn't taken into account any of these issues. It's too thinly based. He hasn't considered the context. And it's why we say it's right that Hasbro says mere reapplication is not enough. There have to be some additional circumstances. Now, here, where the applicant has publicly declared that it seeks seniority, it's difficult to understand how any overlap is supposed to indicate anything of bad faith in the circumstances. No attempt to hide the matters. In fact, they're relied upon for the benefit of the regulation, which the regulation expressly sets out. And we submit that my learned friend hasn't risen to the challenge of identifying the other circumstances. He has relied on mere reapplication. More than that, in the context of the particular marks that he's raised, there are other reasons why we say the inference from mere reapplication must need more, and they are the matters that we have expressly pleaded in our reply and defence to counterclaim, to which I refer in my skeleton arguments. In my view, having heard how my learned friend relies on evergreening, there's no value in repeating simply what I've said already in my skeleton argument. The only point that I would mention is that the point about the Pantone marks is in his Excel spreadsheet, so if my lords or my lady consider that to be a point of importance, then it can be found there perhaps more easily than by looking at the specifications at the back. I think, therefore, my lords, my lady, you already have the idea that, particularly where you have a UK and EU mark, something more than the reapplication must be pointed to. You also have, I think, the point that we make in relation to the 2005 mark, which we rely upon, that it follows practica bow, and that also is part of the context that needs to be explained. But ultimately, the fundamental problem is that reapplication alone is not a problem. Now, that, my lords, my lady, I think takes me to Hasbro. Unlike Hasbro, where there was additional matter, there is no confession here of an abusive intention. To the contrary, we say, plain on their face, on the nature of the very applications that we have made and which are pointed to, are reasons why there were good commercial bases for applying for those marks. I do rely on the point that, unlike Hasbro, we have not sought to assert any new mark so as to avoid the need to show use. And again, this is a point I've made in my written submissions of paragraphs 50 and 51. Indeed, in this case, we say we put in the evidence that we rely on to show use. A point on non-use is, as I say, not one of evidence, but simply of argument as to whether or not it meets the legal test. This is not, if I may put it this way, the usual non-use case, where the issue is, have you made enough use in the right country, in the right 5-year time frame, or in relation to the right specification of goods? That's why, ultimately, we say there is no concordance of factors. The evergreening reapplication point feeds back into the fundamental point about the nature of the wordless mark relative to the mark of the text. The other issue on Hasbro is this suggestion that there is a conflict between it and the judgment of the Court of Appeal in Sky King. 3 short points on it. The first is it appears to be common ground that it's irrelevant because neither side contends for mixed motivations. The second point is the one that my Lord Justice Lewison made, which is that it emerges from the Court of Appeal authority and is thus binding on this court. We do say that my learned friend is wrong, and this is the third point. What he has mistaken is the nuance of Hasbro, because in Hasbro there were multiple specifications of goods. The General Court's judgment looks at each of the specifications and determines that there is only one explanation for some of them, and it's that sole explanation that they say applies and is in bad faith, so that the mixed motivations did not apply to every part of the specification. That is, I think, where the difference has arisen. But the reason why this is significant is that, as far as we can tell, this is the only point where my learned friend says that the judge at first instance erred in law. Beyond that, we submit that what he has done is come before you and re-argued the case that he made before the judge. Every one of the points that he raises to you now are ones that the judge expressly addresses individually and cumulatively in her judgment. And her conclusion is that they do not raise a prima facie case that my client must meet. And we say that that is not an unreasonable conclusion for her to come to, and that it should not be altered on review. Now, this morning, my Lord Justice Arnold challenged me by reference to the Kinder case and the Target case. And in reflection over lunch, I thought I was a little bit too quick and dismissive of the question that my Lord asked me. And I think the reason that I was, the submission I make to you, is that these are fact-specific cases on bad faith, and that I hadn't focused on Kinder and Target as being applicable here, not because I don't agree with the idea that bad faith can manifest itself in the form of a defensive mark, but because the issue that I say was raised before the learned judge at first instance was not about that abstract possibility, but rather about the specific matters that were raised by my learned friend in this particular case.
Well,
and so,
I understand that it's common ground between you and Mr. Mullenage that all these cases depend on their own facts.
yes,
But of course, at this stage, we're simply concerned with what's in the statement of case.
Yes.
And that's why Kinder in particular is of some interest.
yes,
Because if we look at Kinder, we can see what was pleaded in that case.
yes,
So this is in the authorities bundle at tab 5,
yes,
page 69 in the bundle, paragraph 14.
yes,
And so all that was alleged in that case was that the proprietor did not have any intention of using the trademark. Further, the proprietor simply filed this registration in an attempt to obtain extended yet illegitimate coverage of the descriptive word kinder.
Yes.
So if that was sufficient not merely to make out an arguable case, but to make out a case which succeeded in the absence of evidence from the proprietor to rebut that case, why is the pleading in the present case inadequate, even at this stage?
Well, I make 3 points. The first is I think one also has to read paragraph 15, because the allegation was supported by evidence from Mr. Rickard. This, of course, being a case in the IPO where the
yes, but that was at the hearing.
Indeed, but
Mr. Kitchen is saying in 40 it's adequately pleaded.
yes, in the IPO, my lord, where the approach is different. But to the extent that there is a parallel between paragraph 14 and the circumstance of this case, I say that paragraph 14 isn't sufficient, that there should have been a pleading of more. But then, my lord...
So your submission is that Mr. Kitchen was wrong?
If I accept, which I don't, that the analogy is a fair one between paragraph 14 and what's been pleaded in this case. Certainly, my lord, I've taken you through the specifics in this case, which is what I draw your attention to, not an analogy with kinder, but rather to what is specifically said on this occasion to be insufficient. And it's this case that I seek to address. And I do point to the fact that the matters that were pointed to, that were ultimately considered to be enough to raise a prima facie case, and that, I think, is set out slightly earlier. In fact, one can see it, I think, summarised in the head note, where it's suggested. Sorry, my lord, I have the reference. Just give me one moment. Where the term is it 16? The phrase prima facie use. I apologise. I had it. It may well be. Yes, that is what I'm thinking of. So it is from the head note rather than the judgment. The hearing officer found that the sheer number of marks applied for, and which had apparently remained unused, and the period of time over which the application has been made, raised a prima facie case requiring a response from the registered proprietors. We say that's a matter of judgment. The judge in this case has seen the matters that are pleaded, and her conclusion is that they didn't raise a prima facie case requiring a response. And that's quite right, because the matters that are pointed to are all things that, on the authorities, we're expressly told, do not permit, not just ambiguously, but expressly, do not permit, in and of themselves, that inference of bad faith. And so it's for that reason that we say the judge agreed with us, and in doing so, shut out a part of the case that adds, as my learned friend fairly accepts, nothing to the infringement position, because he retains his revocation allegation, which has as its premise this idea that we haven't made use under the Specsavers approach to use of a mark through use of the mark of text. And he retains his point about lack of distinctive character. It's fair to say that we did run the argument at first instance, but for that reason it should be shut out as a Jamil abuse, and we failed on that point because there is a technical difference in the terms of the period of effect between revocation and
you have no respondent notice.
And we've not challenged it. We say there again is an example, something which we disagree with, which can't be said was an unreasonable conclusion for the judge to have come to. So we say should be at the position in relation to this appeal. If you would give me one moment. My lord, you took me to Kinder, which I took to be your most important example. I'm happy to talk about Target Ventures. There, one of the factors was that there was evidence that the applicant for the mark had met the intervener at an earlier event, and it was specifically directed towards their activity that the new application was being made. So it's a bit like the Lint case. And there was a dispute between the Board of Appeal and the General Court as to the significance of all of that material. But we say, once again, that's why you can't really look at the different cases to see whether or not they're analogous. And anyway, I understood my Lord Justice Arnold's point to be one about whether or not this kind of activity can be bad faith, which we fairly accept it can be. Our challenge is, have you identified that it is so in this case, in such a way that I must come to court and answer the issue on bad faith?
Thank you. Yes, any reply, Mr. Arnold?
Lord, a few points in reply, very briefly. Just on the last point, I remind the court of the judgment of the General Court in Hasbro. It must be borne in mind that it's apparent from the case law above the absence of a factor which the Court of Justice or the General Court held to be relevant for the purpose of establishing that it was bad faith in the specific context of a case brought before them does not necessarily preclude a finding that another trademark applicant acted in bad faith in different circumstances. The points I wanted to come back on are only a few. The first of them was a learned friend suggested that the judge during the application had invited us to amend. That is not correct. The judge did say, do I have anything else to add? I mean, that's not at all indicative that there was anything defective or a shortfall in any way, and indeed my recollection of the hearing, the transcript's not in the bundle, but my recollection of the hearing was that the points on amendment came very much in the judgment itself, the draft judgment. I wanted to pick up on the points made by Lord Justice Arnold on the basic common ground in this case, namely that there's been no use and that there's been an intention to expand the protection. Not only was that common ground, but that was the finding by the judge, because if you look at paragraph 80 of the judgment, the judge proceeded on the basis that there had been no use. And if you look at paragraph 76, the judge noted that Lidl had conceded that there, or indeed averred, that there was an attempt to expand monopoly protection. So not only were these common ground, but these were parts of the judgment. And this is really the nub of my learned friend's initial application, and also resuscitated again before your lordships. He contended that if the use is accepted legally, then that deals with the bad faith case. I must lose. But that's not correct, because the question of the intention 30 or 27 years earlier is a completely different legal and factual question to whether a court many years later decides that as a matter of fact there has been use. And as I say, it's even worse for my learned friend if the judge has found as a matter of fact that there was no use, or at least proceeded.
Well, she hasn't found that.
Proceeded as a matter of
She's proceeded on
such
that basis.
That's what I mean, sorry. Another theme of my learned friends, both the submissions made before the judge and before your lordships, was something that I must confess to being somewhat puzzled by, and perhaps a little unfair on my learned friend, because we were a little unsettled on our side when we heard the various justifications that came flying in council submissions about the reasons for reapplication. It was a brand evolution. We heard seniority today for the first time. We heard practica bow offered as a justification. We even heard a new one today that there were, it was easier to register devices under the 94 Act, and that was a possible justification. And in fact, I now understand my learned friend was not seeking to introduce evidence by way of council submission. What he was trying to do was to argue that if there is a possible innocent justification, then I'm not allowed to raise an inference that that's wrong. And that really is his submission. And we say that is tantamount to saying that if there is any possible justification that's innocent, I cannot infer that what has been done is bad faith. To take the example given by my Lord Justice Lewison, if the man accused of fraudulent misstatement can say, well, it's possible that somebody else could have been honest, I wouldn't be allowed to raise an inference that he's being dishonest. And that is the argument, boiled down to its bare essentials, and that cannot be right. We have raised reasonable inferences based upon facts that are established or common ground or to be assumed by the judge, and therefore the inferences are perfectly reasonable. It's really for my learned friend to put forward the real justifications. It was put in another way a moment ago, which was, we haven't pleaded all the circumstances. How does that work? Are we supposed to plead there wasn't seniority, there wasn't an expansion as an EU right, there wasn't a practica bow, change of practice? It doesn't work. We look at the marks, they've been reapplied for. There's a prima facie case of reapplication, and also the second factor, reapplication in order to avoid use, because being defensive marks, they are going to run into use problems. And we raise the inference. It's a perfectly reasonable inference. And my learned friend has defended some of the marks and some of the reapplications in his pleading, and others he has not. I think, just checking my notes, see if there's anything else. On the Hasbro case, the multiple purpose versus sole purpose, a point which I should have raised in response to the question earlier. Hasbro was a pre-Brexit case by the General Court, which is a part of the CJEU, and therefore it is binding on the court. So beyond that, I wasn't going to say much more, because as my learned friend said, we contend for it being a sole justification, but even if it were one of multiple justifications, that would be sufficient under Hasbro. Lords, I have no further submissions to make unless...
Yes, thank you very much. Well, thank you very much for your very economical arguments. We will reserve our decision. You will get draft judgments in the usual course. They will be circulated to those who've given their email addresses to my clerk, that's Lord Justice Arnold's clerk. That will be your opportunity to make typographical corrections, but no more. The draft judgment will come with a fierce embargo, which means what it says. Any breach of the embargo may be treated as contempt of court. We would hope that in the light of the draft judgments, you will be able to agree a form of order. If you can't agree the form of order, please make short submissions in writing, and we will make the form of order we consider to be appropriate. The hand down will be electronic in due course, so there will be no need for any further attendance. Thank you very much.